The criminal law question from July of 1999 is an unusually difficult criminal law question. What's hard about it is the topics that are covered are not that conventional for essay purposes. It's more the stuff from the multi-state. And also, because it's a bit of a racehorse, there are a lot of issues present, and if you're not well organized going into writing your answer, it's very difficult to finish on time. So, a lot of the methods that we already have examined in our earlier subjects are going to come in handy here. Take a look with me at the call of the question. Based on the above facts, 1. Should Al, Bob, or Charlie be convicted of A. Conspiracy to violate the Tariff Act, B. Theft of the truck? Discuss. Well, let's just pause here for a moment. We already know that we've got 6 short answer questions on our hands. Conspiracy and Al, Bob, and Charlie. Theft and Al, Bob, and Charlie. There are a couple of different ways that we might organize this part of our answer. We might organize it around the parties, but I think the better way to organize it is around the charges. And when we get to our examination of my outline, you'll see that's how I chose to do it. It is possible to do it the other way, and plenty of successful applicants did it the other way. But I think the approach that I'm presenting is the easier way. Next, call up the question number 2. Should Al be convicted of attempt to import dutiable goods without payment in violation of the Tariff Act? All right, the substantive charge of attempt. Well, another inchoate crime. 3. If Al persists in testifying that he knew the whiskey was produced in the United States, what, if anything, should Lynn do? Discuss. So, here we get our very first look at professional responsibility. As we will see, it's very common for the examiners to test PR in the context of criminal cases. So, I realize that we have not yet studied professional responsibility together, but we'll take a very quick look at a lawyer's obligations when his client wants to testify falsely. Let's go to the top of the fact pattern and take a look at what actually happened here. This turns out to be a question about that old staple of organized crime, bootlegging. Look at paragraph 1. Al, Bob, and Charlie planned to bring 50 cases of whiskey on shore from a ship in the harbor near their town and sell it to a local bar owner. They believed the whiskey had been produced abroad and was subject to a federal import duty. They also knew that smuggling items into the country without paying a duty as required by the Tariff Act is a crime. In fact, however, the whiskey in the shipment had been produced in the United States. Now, if that doesn't read like something from a multi-state question, I'm not sure what does. Paragraph 2. The 3 met at Al's house on Monday night and agreed to bring the whiskey ashore by rowboat on Friday night. There's the agreement. It looks like there is a conspiracy afoot. On Wednesday, however, Bob called Al to say he and his wife were going to visit relatives that weekend, and Bob would not be able to help bring the whiskey ashore. A withdrawal. Al said that was all right, that he and Charlie would handle the unloading the whiskey, but that Bob would naturally be cut out of the profits from the job. Well, it looks like we had an agreement, but here Bob is withdrawing before any apparent overt act. Paragraph 3. When Charlie learned from Al that there would be just the 2 of them, he became apprehensive, but he was afraid of what Al might do to him if he tried to back out. Therefore, on Thursday, Charlie informed the police of Al's plan and did not show up on Friday night. So, here, Charlie has both withdrawn and taken a step to prevent the crime from taking place. Al was arrested on Friday night as he came ashore, alone, with the whiskey, and he was loading it into a truck that he had stolen from a nearby parking lot. Probably it's a bad idea to steal trucks from the military. Here, the Coast Guard, this guy got caught. Plus, we noticed that there was no talk of stealing a truck during the initial conversation. In paragraph 4, we find out about the charges, Al, Bob, and Charlie. We may call them A, B, and C for short. They've been charged with theft of the truck and conspiracy to import dutiable goods without payment of duty. Al also has been charged with attempt to import dutiable goods without payment of duty, and he has told Len, his lawyer, that he plans to testify he knew all along that the whiskey was produced in the United States. Presumably, that is false. And then we get the call of the question again. Well, I've already alluded to how to outline this question a little bit, but let's turn the page and take a look at how I really did it. You'll see that I have separate sections in my answer, part 1, to conspiracy and to theft. And you'll see that I indicate the basics of the analysis for all three parties right here in the outline. This takes a fair amount of time to do. Now, I think we can outline an answer to this question in between 15 and 20 minutes. And when I outlined this answer, it took me about 20. And the way I come up with these drafts is I do it under exam conditions, and then I rewrite and tinker with my answer as I look at other published answers and think about it myself. So you get the benefit of my second or third or fourth draft. The bar examiners are going to judge you based on your first draft. And that's another great reason to try to outline carefully and prepare to make your answer as much a series of short answers as possible. So, with regard to Al and conspiracy, we talk about impossibility and mistake. With regard to Bob, we talk about withdrawal, and with regard to Charlie, we talk about withdrawal plus the fact that he thwarted the crime. With regard to theft, Al did it, so he faces direct responsibility. Bob and Charlie may face liability based on conspiracy theories. In part 2, we talk about Al's possible liability for attempt to violate the Tariff Act. Here we deal with impossibility. That's really his only possible defense. And then we turn to the PR aspect, and you'll see here I actually go into duties that an attorney owes. The duty of zealousness, the attorney-client privilege, and the duty of candor, and then I reach a conclusion. Now, I wouldn't be too concerned if you didn't spot these issues very well on PR. But I do think it's worth having a look early, so I gave you the pleasant surprise of a couple of issues that maybe you haven't been prepared for yet. It'll be a good chance to have a look and see how good your instincts are, if nothing else. So now let's see how this answer plays out. I haven't given you the bottom lines, as I often do as we review the outline together, so let's actually have a look at the answer, both for technical purposes, to see how I've sketched it out, and also a little bit for substantive purposes. On the multi-state, this material is tested a lot more frequently than it is on the essays. So, on an essay dealing with the inchoate crimes, once again, we lead with the facts, we tie the facts to the law analytically, we reach specific conclusions that make sense and flow from the facts. Notice up front, with regard to conspiracy, before I get to consider any of the parties, I lead with a definition in a factual context. I establish what the prosecutor has to prove in order to win convictions against these three men for conspiracy. The prosecutor must show an agreement with the intent to agree, and many jurisdictions also have an overt act requirement. So we focus on Al because he's the one who's listed first, and it's also apparent that he's the ringleader and the one most likely to face the greatest degree of criminal liability for his conduct. The meeting happens at Al's house. I discuss the meeting in the first paragraph under Al, and although it is true that Bob withdrew and Al knew about it, he still intended to commit the crime. And, in fact, he did perform several overt acts towards the target offense. So, with regard to Al, it's clear that he entered into an agreement and he participated in a number of overt acts. So, unless he's got some kind of good defense, he's on the hook for liability for conspiracy. And he does have a colorable defense. Sadly, I don't think it will be a successful defense, and that defense is impossibility. He's going to argue that since the whiskey was in fact domestic, there wasn't a chance of him committing the crime, and therefore he shouldn't be convicted of conspiracy. Sadly, impossibility in this context is not a successful defense. Next, he can argue mistake, and that since he was mistaken about the origin of the whiskey, he can't be convicted. Once again, for basically the same reasons, the defense fails. Hence, I reach the conclusion Al is guilty of conspiracy to violate the Tariff Act. Next, we focus on Bob, and you'll see up front, I lead with the facts. I explain what happened. And it seems as if Bob did have the proper intent at the time of the meeting, but he withdrew before an overt act had been committed. And I say that's good enough for him to escape criminal liability for conspiracy. And in similar fact patterns on the MBE, you'll see the accuracy of my bottom line is well played out. Charlie has an even better defense to conspiracy. Not only did he withdraw from the alleged conspiracy, but he prevented the crime from being completed by alerting the police. So not only did he do nothing to further the crime, he prevented it. Therefore, I say Charlie escapes liability for conspiracy. Next, we turn to the theft of the truck. And what a surprise. Up front, I actually give you the definition of theft. It's about as short a definition as you'll see, but it is accurate, and it does set up our further analysis. Since we've got three different parties facing potential liability, I throw out a quick definition. Just as I basically defined conspiracy with regard to the prosecutor's burden in the first paragraph of the first section. So, with regard to the theft of the truck, we focus on Al. That's an easy bottom line. He almost certainly is liable for theft, except perhaps he did not intend to permanently deprive the Coast Guard of their truck. Maybe he was just going on a quick joyride to complete the crime. So, perhaps, in fact, he will escape liability. I do consider it a close call. Bob and Charlie can't be convicted of this crime because both of them withdrew well before it took place, and, in particular, Charlie thwarted the crime, and therefore he is going to escape criminal liability. Next, we turn to Al and his possible liability for violating the Tariff Act, or attempt to violate the Tariff Act. And here, once again, we have to carefully deal with the facts about the fact that it was perhaps impossible for him to commit this crime. But impossibility is not a bar to conviction for attempt. And that's the bottom line of my analysis. Ultimately, I conclude that Al is guilty of attempt to violate the Tariff Act. Next, we turn to the PR aspect of the question. And here, acknowledging that we haven't worked on this topic together yet, take a look at how I do the analysis. Up front, right below Roman numeral number 3, I lead with the facts. I indicate what Al has done, and I indicate that Len is going to have to be careful in order to balance some ethical duties that, it turns out, are in conflict with each other. It's common in criminal law cases for the duty of zealousness and the attorney-client privilege to have to be balanced against all attorneys' duty of candor to the opponent and to the tribunal. In the criminal law context, it is fairly consistent that the criminal attorney's liability for PR violations is more commonly breached when the attorney does in his client than when the attorney compromises on the duties owed to the adversary and the profession. So, here in California, there is black letter law that is worth knowing. Here, the lawyer cannot prevent his client from testifying, and he can't inform the court of his client's perjury. At the same time, the lawyer is forbidden from arguing any testimony that he knows to be false. So, once again, the duty of zealousness and the attorney-client privilege appear to dominate criminal defense attorneys' ethical obligations. Don't worry about PR right now. We will spend plenty of time on it in the not-too-distant future. But this is a good essay to focus on in criminal law because it tests, in the essay context, topics which are far more commonly tested on the multi-state, hence its value to our work.